When an accident claim involves future medical care, the settlement has to answer an awkward question. Who pays when the check is gone, but the treatment is not? That is where a Medicare Set-Aside, often called an MSA, enters the story like a tiny financial seatbelt. An MSA is money reserved for medical services related to the injury that Medicare might otherwise cover later. It is not a bonus fund, a secret vault, or permission to buy a jet ski because your knee hurts. The idea comes from a simple rule. Medicare generally should not pay first when another party, such as an insurer or a workers' compensation carrier, is responsible for an injury. The government wants the settlement to handle those injury-related costs before Medicare steps in. Your lawyer starts by gathering medical records, bills, treatment plans, prescriptions, and opinions about what care you may need in the future. Doctors, nurses, or specialized reviewers may estimate the price of surgeries, therapy, equipment, medicine, and follow-up visits. That estimate is not pulled from a magic 8-ball, although paperwork can sometimes feel like it was designed by one. The review usually considers your age, diagnosis, treatment history, expected lifespan, medication needs, and whether future care is reasonably connected to the accident. The proposed amount may then be submitted to the Centers for Medicare and Medicaid Services, commonly called CMS, for review. In some situations, CMS reviews the proposal and suggests an approved amount, while in others, the parties calculate and document the set-aside without formal approval. Approval is not always required, and eligibility for review depends on facts such as your Medicare status and the type of claim. That detail matters because a settlement plan should fit your situation, not copy a form from the internet wearing a cheap disguise. Once the amount is established, the settlement documents explain how the money will be managed. It may be placed in a separate account, handled by a professional administrator, or managed by you under specific rules. The funds are meant for injury-related medical expenses that Medicare would normally cover. You typically cannot use the money for unrelated groceries, vacation snacks, or an ambitious collection of garden gnomes. When a medical bill arrives, the administrator or account holder checks whether it qualifies. If it does, the account pays it, records the payment, and keeps proof in case Medicare or another agency asks for an audit later. After the set-aside is used properly, Medicare may begin paying eligible future treatment, subject to normal Medicare rules. That does not mean every bill becomes free, because deductibles, coinsurance, coverage limits, and unrelated conditions still matter. Medicare Advantage plans and prescription drug coverage can add another layer, since they may have separate recovery interests. Your legal team may need to identify and resolve those claims too, rather than treating Medicare paperwork like a pile of laundry that disappears when ignored. The settlement should also address Medicaid, private insurance, hospital liens, and other possible reimbursement claims. These are different systems with different rules, so one big check does not automatically make every problem vanish. Good planning protects more than the settlement money because it can reduce the chance of benefit interruptions or payment disputes later. It also gives you a clearer map of what the money is for, which is helpful when legal documents start sounding like a robot swallowed a dictionary. The exact process depends on the facts, the type of claim, your benefits, and the expected medical care. So you should ask your accident injury lawyer how the proposed set-aside was calculated and who will administer it. If you want to learn more about our company, check out our links in the description.